All right, so I don't have a ton for you guys today that is new, but one piece of sort of breaking news. You may remember a few weeks ago I had told you about a federal judge who had ruled that orders by Governor Wolf to shut down businesses and limit gatherings to tackle COVID-19 were considered unconstitutional. And it didn't matter that much because a lot of the shutdown orders were passed, but it may be an impact in the future because who knows what's going to happen this winter. So Governor Wolf, not surprisingly, appealed to the Third Circuit Court of Appeals on October 1st. The Court of Appeals issued an order staying portions of the original federal judge's ruling. So at least for now, the governor can continue restricting public gatherings. Keep in mind that the Pennsylvania current limit, this has changed a couple of times, but the current limit is 25 people for indoor events and 250 people for outdoor events. But stay tuned. We'll see what happens as we go forward. And then I mentioned this last week, but I do like to usually mention things at least 2 weeks in a row for anybody who might not have been on last week. So Philadelphia has amended its paid sick leave law for workers who may not be eligible for coverage under the Families First Coronavirus Response Act. And for those of you, I think probably everybody has heard of FFCRA by now, but it does provide some paid leave time for employees of employers of less than 500 employees. The nice thing about the nice thing from the workers' point of view about the Philadelphia law is that it extends to independent contractors, but it basically covers the same 6 reasons that FFCRA covers. So if you do have employees in Philadelphia or you do have workers in Philadelphia who you thought might not be covered under FFCRA, it is possible that they might be covered under the new Philadelphia law, so something to be aware of. And then I also did mention this last week, but again, this is such a big issue with regard to back to school. So I read a recent survey that I thought was really interesting. It's from Catalyst and CNBC about polling working parents about sort of how they're feeling about their jobs right about now and how they're feeling about their employers right about now and how they're struggling really with trying to get their kids in school and still meet the requirements of the job. So nearly 40% of their employer does not have enough benefits for parents to support them as their kids are engaged in virtual or hybrid learning. 55% fear that if there are going to be people who are going to go, they're going to be layoffs, they're going to be furloughs, they'll be in the first group because they are working parents and because they're struggling right now. 41% say they have less job security than pre-pandemic. 38% say they fear being penalized for being a working parent. 41% of mothers and 36% of fathers say they've had to hide their caregiving struggles. They're afraid if they let their employer know the extent of their struggles, it's going to come back to haunt them. 42% say it would be a risk to their employment to take advantage of child care offerings that are available to them. So even though there are benefits there being offered, they're afraid to take advantage of them. And 39% worry they will be terminated if they ask for help. So this just sort of highlights for employers that we really need to let our working parents know that they are supportive, that the benefits are there for them to take. So I've asked these questions before. What kind of flexibility can we offer at work? What kind of flexibility can we offer from work? And what kind of subsidizing can we give to caregiving programs? So a couple of interesting ideas. Again, I mentioned these last week, but they bear repeating. I read a really nice article about some larger employers and what they're doing, but it might give you, and I understand these larger employers have the resources to do this, but it might give you some ideas. I think this Paylocity idea is actually an idea any employer can take advantage of. Just having employees individually sit down with their managers. These are employees who have flexibility, right? So this isn't a production employee who needs to be in the machine for 8 hours, but if you have employees who are working from home and it really doesn't matter what time of day they're getting their work done, or maybe you need to set core hours, 3 or 4 core hours a day, and then they get the rest of their work done. Have them sit down with their managers and figure out what works for them. What's a schedule that works for both the flexibility from work. So I said before, FFCRA is for employers of 500 employees or less. The idea behind that was that bigger employers would step up and they would do what should be done anyway and give their employees flexibility. So here's a couple of good examples. Microsoft, again, understand it's a huge employer, but those employees received an additional 12 weeks of paid parental leave earlier in the year. Back in April, Google extended their family leave to 14 weeks. So things that you can think about doing. We have heard about smaller employers adding to PTO banks, for example, to try to help people get a little bit more flexibility. And then how about caregiving programs? A software developer, Globin, they provide virtual activities for kids like art classes, movement breaks, magic shows. So those are run by professionals. So the child can be on their computer or iPad, presumably next to the employee. The employee can be working while the child is engaged in something else. And I think we heard about a lot of this stuff early on. We heard about the virtual yoga classes. We heard about the virtual different types of classes that were going on. And I think that faded out a little bit after the first couple of months of the pandemic. Something to think about. Is that something you can do? Could you do magic shows? Could you do an art class for your employees' children? And then Toyota created a program at one of their Kentucky manufacturing plants. So they bring the kids in so that the parents don't have to stay home for virtual learning. The kids can come in, they can be supervised while they virtually learn. The parents can be working on the production line or in their offices, but they know that the kids are being taken care of. The kids are being instructed or led through their virtual instruction by someone with training, and that also includes aftercare. So again, a lot of employers aren't going to be able to do that, but can you do something similar to that? Is there something creative you can get behind to help your employees right now? And then the lawsuits are here. So you guys have heard me talk about this for months, that we all were trying to do the right thing during the pandemic. And we were all trying to just to get by, obviously, to have our businesses survive. But the first wave of lawsuits really has started. Well over 800 employment-related lawsuits have been filed in state and federal court. But that doesn't include all the government filings at the EOC, DOL, similar state agencies. So they are coming. But keep in mind that most lawsuits don't start as lawsuits. They start as demand letters. Very often you will get a letter from an attorney on behalf of one of your former employees saying, hey, I think that my termination was not proper. I think that you discriminated against me. I think that you harassed me. I think that you, I had a question, 800 lawsuits just in Pennsylvania. No, that's national right now. But keep in mind, we're so early on in the process. Most lawsuits don't get filed for several months, even maybe a year plus from the time that somebody is terminated. And for a lot of discrimination lawsuits, they have to go through a federal or state agency first. So 800 doesn't sound like a lot, but trust me, they're coming. So like I said, you usually get a demand letter. Most of the time, an attorney looks at a situation, they say, well, if I don't have to file a lawsuit, let's not file a lawsuit. I'm going to send the employer a demand letter. I'm going to ask for some severance, or I'm going to ask for a settlement amount, and see if we can do this without litigation, because from the attorney's point of view, right, that's some quick money for the plaintiff's attorney. So what should you do if you get a demand letter? Easy, don't ignore it, okay? It's very easy to say, oh, that's frivolous. I'm not even going to dignify that with a response. But the reality is that I think you might actually make the situation worse by ignoring it. A lot of attorneys play pop psychologist, and I do believe sincerely that people are more likely to sue you when they're angry with you, and ignoring the attorney letter is probably just going to get somebody angrier at you. Not to mention the fact that once they have an attorney involved, they don't usually walk away. So it's a good opportunity to try to resolve it. Next question is, who in the organization needs to know? Not everybody, okay? You want to keep it as confidential as you can, but there are going to be decision makers who are going to need to know. How do you let them know? Probably not in writing, at least not at first. See if you can get on the phone. If you're virtual, get on a Zoom, talk about it, and just make a decision. Because keep in mind, those early on conversations and communications probably are not privileged. You don't have an attorney involved yet, so be careful about what you put in writing early on. Call your insurance broker. Do you have insurance? There's something called employment practices liability insurance, EPLI. Many employers do now have it. And in my experience with our members, a lot of our members don't know they have it. So call your broker first and say, is there insurance coverage here potentially? Put your insurance carrier on notice as soon as possible so they can't deny the claim for lack of notice. It may very well be that they don't get involved, especially if it's a severance being contemplated. Pay severance. That's fine though. Put them on notice, protect the claim. And then of course, talk to an attorney. If you have a law firm you do business with, call them, see if they can help you. If you're an MEA member, the attorneys here, we deal with demand letters on a regular basis, and we're happy to walk you through that and help you through that. I've recently settled a couple of matters for members, and while nobody likes paying out money, it is much better than the alternative, which is to spend time, energy, and money going forward in a lawsuit. Okay. And one other point, I've said this a few times, but I think it bears repeating. Really think about what you're doing around flu shots and potentially around a COVID vaccine. Do you want to try to mandate this? Generally speaking, it's only been healthcare employers who've tried to mandate flu shots in the past. And you really, really need to think it through. If I'm going to say it's mandatory, well, what am I going to do if employees say no? Am I prepared to fire people because they're not getting a flu shot? The EEOC has said that the employer can establish legitimate health and safety requirements that are job-related and consistent with business necessity. If all your employees were remote, it's going to be hard to establish that we need a flu shot. But if everybody's coming in, maybe you can. But keep in mind that there also are reasonable accommodations issues around this, around ADA and religious accommodations. So you really need to think it through. And I think with regard to flu shots, what might be a better alternative than trying to mandate outside of a healthcare setting is that you just make it as easy as possible for your employees to get their shots. Tell them where they can go, give them a paid hour off of work. Maybe it's not too late to do a flu clinic where you are. So something to think about. And then one other point, I keep hearing from so many of you, so many of our members, how happy they are with what we're doing through the COVID crisis. I'm so happy to have us to talk to, so happy with the webinars. So remember, for members, there is a Refer a Peer rewards program. Your employer will get 20% off the dues, but if you're the person who refers somebody who signs up, you get a $100 gift card, which is pretty cool. So please think about referring us to your peers and to your friends. So it doesn't look like we have any other questions, and I know we're running a couple of minutes over. But thank you guys so much. We will see you next week.